There's been a recent, quite significant and interesting decision of the federal court in a claim brought by an employee in relation to misleading or deceptive comments made to her which induced her to accept a position with, in effect, a competitor of her employer at the time. She was offered a base salary of $115,000, which was around $100,000 less than she had been receiving in her current position. But what was, she was offered 2.5% of profit, and what was put to her is she'll be able to make up and more the difference because she's going to get this large profit share component. Critically, in the pre-contractual phase, representations were made to her that she would make up the difference for the profit in the year she was employed based on statements that were made about the actual profit figures in 2011 and 2012. When she commenced employment, she soon learned that things weren't exactly as they had been represented to her, and as a result the company actually made a net loss in the 2013 year, meaning that she was just left in effect with her base salary and other fixed remuneration entitlements and no profit share, and had suffered a substantial loss as a result of having taken the position. The key issue was whether representations had been made in the course of employment, and it was in the course of her considering whether to take the position, and it was found that they had been made, particularly in relation to the actual profit figures for 2011 and 2012.
So what was fundamental in this case was the fact that the assurances or representations made to the employee were based on incorrect information. So the company here had said that they had made a profit in the prior 2 years when in fact there had been a net loss that had occurred. And it was on that basis that the court held that there had been a misrepresentation. They found specifically that the forecast for 2013, if there hadn't been that assurance about past years, that in and of itself wouldn't have resulted in a misrepresentation. And as a distinction, so she was awarded $333,000 in damages to compensate her for that loss as a result of that misrepresentation. In contrast, she claimed that the employer had told her that they would pay for her car costs. She was issued with a written contract subsequently that stated nothing about covering those vehicle costs, and as a result the court ruled that, well, in fact you're not then entitled to those costs because you should have been aware from the written contract that that was not an agreed term. And I think it's a really important case for employers to know about, because lots of employers are used to sort of breach of contract type cases where if they do something wrong or if there's some sort of breach of contract, this can result in a payment of the notice period under the contract. A misleading case under the Australian consumer law is entirely different and can open employers up to significant amounts of damages because it's based on the loss that the individual employee incurs as a result of those assurances or misrepresentations.
And again, as Lucienne says, it's so many cases of this nature have failed because they've been found to be about future events where it's very hard to establish that the representative didn't have reasonable grounds for making those representations. And this would have, if it had just been about future events, 2013 profit had been another one that failed. It's when it gets into the misleading representations about what has occurred that it can be very, very serious.